Going by that definition and comparative jurisprudence, amendment of the Constitution through popular initiative cannot be undertaken by the government when it is the same entity that is being compelled to undertake the amendment, and in default, the amendment to be subjected to a referendum. It is therefore clear from our constitutional scheme that there are two ways in which a constitutional amendment can be initiated, either by parliamentary initiative or by popular initiative. The said provisions are in sync with the provisions of Article 1, Sub-Article 2, or Clause 2 of the Constitution, which provides that the people may exercise their sovereign power either directly or through their democratically elected representatives. Since Article 2, Clause 2 of the Constitution, since under Article 2, Clause 2 of the Constitution, no person may claim or exercise state authority except as authorized under this Constitution, it necessarily follows that, subject to what we have stated elsewhere in this judgment as regards the role of primary constituent assembly, there is no other constitutionally permissible avenue available to any person to initiate a constitutional amendment save by the prescribed ones, parliamentary and popular initiatives. We shall come back to this issue in due course. We now proceed to deal with the question whether the Constitution Amendment Bill falls within the initiatives contemplated in Chapter 16. It is not in doubt that via Gazette Notice number 5154, the President set up the task force on building bridges to unity advisory. As outlined above, the mandate of the task force was to outline the policy, administrative reform proposals, and implementation modalities for each identified challenge area, and conduct consultations with the citizens, the faith-based sector, cultural leaders, the private sector, and experts at both the county and national levels. Whereas one may well argue that in setting up the task force, the President was undertaking his constitutional mandate under Article 131, Clause 2C of the Constitution, which enjoins him to promote and enhance the unity of the nation, his subsequent action is, however, the subject of controversy. Pursuant to the report of the task force via Gazette Notice number, Special Issue number 264, dated 10th January 2020, the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report was established, comprising of the same members of the task force. The committee's role was expressed to conduct validation of the task force report through consultation with citizens, civil society, the faith-based organizations, cultural leaders, the private sector, and experts, and to propose administrative policy of constitutional changes that may be necessary for the implementation of the recommendations contained in the task force report, taking into account any relevant contribution made during the validation period. The steering committee submitted the report to the President on 21st of October 2020, consisting of a raft of proposals on constitutional and legislative amendments, as well as draft constitutional amendment bill, draft legislative bills, administrative measures, and other recommendations. With that report, the seed for constitutional amendment process was sowed. From the foregoing, it is clear that the Constitutional Amendment Bill is an initiative of the President. It cannot be otherwise, since the task force was set up courtesy of his initiative, and the subsequent steering committee was tasked with implementing the task force report and the membership of the two entities remained the same. Under Article 131, Clause 1b of the Constitution, the President exercises the executive authority of the Republic with the assistance of the Deputy President and Cabinet Secretaries. Under the Constitution, the President is not a member of Parliament and therefore cannot directly purport to initiate a constitutional amendment pursuant to Article 256 of the Constitution. This is because under Article 94, Clause 1 of the Constitution, the legislative authority of the Republic at the national level is vested in and exercised by Parliament. It follows that the President has no power under the Constitution as the President to initiate changes to the Constitution under Article 256 of the Constitution, since Parliament is the only state organ granted authority by or under the Constitution to consider and effect constitutional changes. The President, if he so desires, can, however, through the Office of the Attorney General, use the parliamentary initiative to propose amendments to the Constitution. As we concluded above, both a textual analysis of a Constitution and a historical exegesis of the clause on popular initiative makes it clear that the power to amend the Constitution using the popular initiative route is reserved for the private citizen. Neither the President nor any state organ is permitted under our Constitution to initiate a constitutional amendment using popular initiative. Beyond the text of the Constitution, there is another reason it is impermissible under our Constitution. In our view, to permit the President to initiate such amendments through a popular initiative and then sprint to the finishing line to await and receive it and to determine its ultimate fate would have the effect of granting to him both the roles of the promoter and the referee. This is because Article 257(5) of the Constitution provides that if a bill to amend this Constitution proposes an amendment relating to a matter specified in Article 255(1), the President shall, before ascending to the bill, request the IEBC to conduct within 90 days a national referendum for approval of the bill. In other words, Article 257, Clause 5 of the Constitution arguably gives the power to the President to determine whether or not a referendum is to be held. In circumstances where the President, whether in his official or personal capacity, is the promoter of the amendment bill, his role in determining whether or not the bill is to be subjected to a referendum may well amount to a muddled up conflict of interest. The President cannot be both player and the umpire in the same match. Next is the question whether the Constitution Amendment Bill is a state-sponsored initiative and whether it qualifies as a popular initiative as envisaged under Article 257 of the Constitution. From the discussion above, it is clear that the initiative to amend the Constitution was conceived after the task force presented its report to the President, who then appointed the steering committee. That process was spearheaded by the President as the Chief Executive of the Republic of Kenya, who then appointed the steering committee and included in its terms of reference the following term, quote, to propose administrative, policy, statutory, or constitutional changes that may be necessary for the implementation of the recommendations contained in the task force report, taking into account any relevant contributions made during the validation period, unquote. It has been argued that the President was acting in his personal capacity and not as the Chief Executive of the Republic of Kenya. This argument is, however, betrayed by the very fact that the BBI Steering Committee was established via a Gazette notice, an official publication of the Government of the Republic of Kenya, and its report was addressed to His Excellency the President of the Republic of Kenya and the Commander-in-Chief of the Defense Forces, Honorable Uhuru Kenyatta, CGH, unquote. More importantly is the question whether the President can, under the guise of being a private citizen, exercise the powers of amendment reserved under Article 257 of the Constitution. A textual reading of Article 1, Clause 2 of the Constitution, which I have referred to above, reveals that the powers thereunder are exercisable either directly or through their democratically elected representatives. The employment of the phrase either directly or is a clear manifestation that the drafters of the Constitution intended that there be a distinction between direct and representative exercise of sovereign power. This court, in interpreting the Constitution, must do so holistically, as we have explained above, as was held in the case of Tinyefuza versus Attorney General. In our view, in interpreting the Constitution holistically, as we are enjoined to do, Article 1, Clause 2 must be read together with Articles 256 and 257 of the Constitution. When one considers these provisions together, the only reasonable conclusion is that the Article 257 of the Constitution is reserved for situations where the promoters of the bill do not have a recourse to the route contemplated under Article 256. Our view is in tandem with the historical genesis of the provisions we have set out herein above. In other words, the Article 257 route is meant to be invoked by those who have no access to Article 256 route. Those who have access to Article 256 route are therefore barred from purporting to invoke Article 257 route. There is no doubt that the President, if he intends to initiate a constitutional amendment, may do so through the aegis of Parliament. It follows that since the Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force was a brainchild of the President, it has no longer standing in promoting constitutional changes pursuant to Article 257 of the Constitution. It is our view that a popular initiative, being a process of participatory democracy that empowers the ordinary citizenry to propose constitutional amendment independent of the lawmaking power of the governing body, cannot be undertaken by the President or state organs under any guise. It was inserted in the Constitution to give meaning to the principles of sovereignty based on historical past, where the reservation of the power of amendment of the Constitution to the elite few was abused in order to satisfy their own interests. The respondents and some interested parties have taken refuge in the fact that there were previous initiatives sponsored by the state in 2005 and 2010 to amend the Constitution as a basis of justifying the role of the state organs in the popular initiative. It is important to note that the previous initiatives were undertaken under the retired Constitution. At that time, there was no provision for two initiatives as provided under the current Constitution. The provisions of two distinct initiatives under the current Constitution lends credence to the fact that the two avenues are distinct and ought not to be muddled up by creation of a hybrid initiative unknown to the Constitution. Therefore, it is our finding that the popular initiative as a means to amend the Constitution under Article 257 of the Constitution is a power reserved for Njiku. Neither the President nor any state organ can utilize Article 257 of the Constitution to amend the Constitution. Now, in this part of the judgment, we now turn to the various questions raised challenging the legality of the entire BBI process, from the establishment of the Steering Committee to the implementation of its finding and report through the Constitutional Amendment Bill and associated proposed legislations. After considering the consolidated petitions, the responses thereto, and both oral and written submissions in support of and in opposition to the consolidated petitions on the specific issue of the legality of the BBI process, we have come to the conclusion that there is not much of a dispute on what, no doubt, are the facts material to the determination of the questions presented. To begin with, it is not in dispute that Mr. Joseph K. Kinyua, who is the head of the public service, informed the public that His Excellency Honorable Uhuru Kenyatta, the President of the Republic of Kenya, had established a task force known as the Building Bridges to a United Advisory Task Force, comprising of 14 members and 2 joint secretaries. It is also not in dispute that this information was relayed to the public through a government publication, being Gazette Notice number 5154 of 24th May 2018, and which was published in the Kenya Gazette dated 31st May 2018. The terms of reference of this task force are also not in dispute and have been reproduced in this judgment. It is worth repeating them owing to their centrality in issue under consideration. We have reproduced them in our judgment. It is also not in dispute that in a special issue of Kenya Gazette of 3rd May 2019, the President published the 6th Annual Report 2018, in which he remarked as follows. We have reproduced the excerpts of the President's report in our judgment. You'll have opportunity to read it when you get the copy of the judgment. Again, it is not in dispute that in yet another Gazette notice published a special issue on 10th January 2020, number 7. This is Gazette Notice number 264, dated 3rd January 2020. The head of the public service notified the public that the President had appointed the steering committee comprising of 14 members and 2 joint secretaries whose terms of reference have been reproduced above. Now, we have had to reproduce all these Gazette notices because they, by and large, triggered the events that culminated in what turned out to be a deliberate process to amend the Constitution, and which has in turn yielded to the Constitutional Amendment Bill. The overarching question that emerges out of these undisputed facts is whether the process adopted in the attempt to amend the Constitution is consistent with the means prescribed by the Constitution to amend it whenever such an amendment is necessary. But before interrogating this primary question, there are issues that have been raised by the Honorable Attorney General, which we must necessarily be disposed of as preliminary points of law. These issues are as follows. First, whether the questions presented regarding the legality of the BBI process are sub judice. Second, whether those same questions presented are res judicata. And finally, whether Mr. Uhuru Muigai Kenyatta can be sued in his personal capacity during his tenure as the President of the Republic of Kenya. The first 2 questions are related, and perhaps for this reason, are respectively covered under sections 6 and 7 of the Civil Procedure Act. We have reproduced the 2 sections in our judgment. The rationale behind section 6 of the Civil Procedure Act is that it is vexatious and oppressive for a claimant to sue concurrently in 2 courts. Where there are two courts faced with substantially the same question or issue, that question or issue should be determined in only one of those courts, and the court will, if necessary, stay one of the claims. Ordinarily, it is the second suit that will be stayed. Two obvious prerequisites necessary to stay a suit under this provision of the law are: one, the matter in issue in the subsequent suit must be directly and substantially in issue in the previously instituted suit, and two, the parties in the two suits must be the same parties or parties claiming under them or litigating under the same title. The basis of the Honorable Attorney General's argument that the issues raised in the petition number 486 of 2020 is caught out by this provision of the law is High Court petition number 12 of 2020, in which one Okia Omtata Okoiti is named as the petitioner. There are 5 respondents in that petition. The first is the National Executive of the Republic of Kenya. The second is the National Treasury. The third respondent is the Presidential Task Force on Building Bridges to a United Kenya Advisory. And the last respondent is the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report. Beside the respondents, 2 other parties have been named as the interested parties, and these are Katiba Institute and Muslims for Human Rights, Muhuri. The prayers sought in that petition have been reproduced in this judgment. I will not go through them. So, going by those prayers, which Mr. Okia Omtata sought in petition number 12 of 2020, there is no doubt that the matters in issue in his petition, which we will henceforth refer to simply as the Omtata petition, are covered in these consolidated petitions. However, it is also not in dispute that the consolidated petitions cover a wider range of issues than those covered in the Omtata petition, to such an extent that due to its wider scope, there would still be a need to hear and determine the consolidated petitions, even if the Omtata petition had been heard and determined. In short, while it is true that the matter in the Omtata petition is directly and substantially in issue in these consolidated petitions, the matter in issue in these consolidated petitions cannot be said to be directly and substantially in issue in the Omtata petition. Only a segment of it is. That aside, it is also clear that the parties in the 2 suits are different. The absence of the petitioner in the Omtata petition in the present petition stands out. It follows that the two prerequisites necessary before a court can order stay of proceedings under Section 6 of the Civil Procedure Act have not been demonstrated to obtain, and therefore there will be no reason of staying these consolidated petitions pending the determination of the Omtata petition. We must add that even if the present suit was on all fours with the Omtata petition, the institution of these proceedings would not have been in any way fatal. The farthest this Honorable Court could go is to stay these proceedings, and staying of such a proceeding is normally necessary to avoid the trial or hearing of the claim taking place where the court thinks it is just and convenient to make the order, to prevent undue prejudice being occasioned to the opposite party or to prevent the abuse of the process. The consolidated petitions, being wider in scope than the Omtata petition, cannot be said to be an abuse of the process. Apart from the fact of filing the Omtata petition, there is no evidence that any further step has been taken towards prosecution and determination of that petition, yet it cannot be denied that the nature of the dispute in this petition demands an expedient determination. For this very reason, we think that it is also in the public interest that these consolidated petitions be resolved at the earliest opportunity possible. Considering the progress that has been made towards its conclusion, culminating in this judgment, it could not have been held in abeyance pending the determination of the Omtata petition, whose program for determination is unknown. If anything, the determination of this suit may, in one way or the other, help resolve the Omtata petition. Related to this issue of sub judice is the question of res judicata, which, as earlier noted, is covered under Section 7 of the Civil Procedure Act. This provision of the law is based on the fundamental doctrine of all courts that there must be an end of litigation. The doctrine of res judicata may be pleaded by way of estoppel, so that where a judgment has been given, which is a matter of record, an estoppel by record arises. The rationale for the existence of the estoppel by record can be summed up in two expressions: that it is in the public interest that there should be an end of litigation, and that no one should be proceeded against twice for the same cause. Estoppel by record may take the form of cause of action estoppel or of issue estoppel. It may also be said that the cause of action has merged in the judgment. Where res judicata is pleaded by way of estoppel to an entire course of action, rather than to a single matter in issue, it amounts to an allegation that the whole legal rights and the obligations of the parties are concluded by the earlier judgment, which may have involved the determination of the questions of law as well as findings of fact. This is a form of action estoppel. Issue estoppel, on the other hand, means that a party is precluded from contending the contrary of any precise point which, having once been distinctly put in place in issue, has been solemnly and with certainty determined against him. Even if the objects of the first and second claims or actions are different, the finding on a matter which came directly in issue in the first claim or action, provided it is embodied in a judicial decision that is final, is conclusive in a second claim or action between the same parties and their privies. Issue estoppel will only arise where it is the same issue which a party is seeking to re-litigate. This principle applies whether the point involved in the earlier decision and as to which the parties are estopped is one of fact or one of law or one of mixed fact and law. The Honorable Attorney General is urging what is certainly issue estoppel. The Honorable Attorney General has not argued that this suit is res judicata as such, but that the specific question concerning the legality or constitutionality and the mandate of the BBI Steering Committee has been resolved by this court. But in the Third Way Alliance case, which is Third Way Alliance and another versus the head of public service and two others. In that case, that is the Third Way Alliance of Kenya, a political party registered under the Political Parties Act number 11 of 2011, which is the petitioner in petition number 400 of 2020 in the present consolidated petitions, sold Mr. Joseph Kinyua, the head of public service, the building bridges to a United Advisory Task Force and the Honorable Attorney General. Among us, the prayer sought in that petition was a prayer framed as follows. A declaration that the body being referred to as the Building Bridges to a United Advisory Task Force established by Gazette Notice number 54 dated 24th May 2018 is unconstitutional, illegal, null, and void. The Honorable Attorney General's argument that the constitutionality and the mandate of the BBI Steering Committee is a question that has been resolved is no doubt based on the learned judge's determination on issues surrounding this particular prayer, and therefore it is necessary to consider what the judge said in respect of this issue. So we have reproduced the excerpts of the judgment of Judge Matiwa J in that judgment, in this judgment. We must set at the outset that we are conscious that the decision in the Third Way Alliance case is cited before us not necessarily as a decision from a court of coordinate jurisdiction persuading us to take any particular position on a point of law, and from which we are entitled to depart if there are reasons to do so. Instead, it is presented in the context of a judgment in rem binding us on a specific point of law. It is from this perspective that we shall consider that decision. Of the several questions that we have been asked in these consolidated petitions, one question that was not asked in the Third Way Alliance case is whether the President can establish a committee or any other entity for that matter to initiate the change or amendment of the Constitution outside the means prescribed by the Constitution itself. To be precise, can the amendment of the Constitution be initiated in any way other than those envisaged under Article 256 and 257? As we understand it, the petitioner's case in petition number 426 of 2020 is that the BBI Steering Committee impermissibly initiated the amendment of the Constitution in the guise of an amendment by popular initiative under Article 257, when in fact it is an initiative by the President hiding behind the BBI Steering Committee. The question we are faced with is whether BBI Steering Committee, which in the petitioner's view was established with the sole purpose of undertaking an assignment that is contrary to the provisions of the Constitution, is constitutional, and by the same token, whether anything done by such committee is unconstitutional. In our humble view, the answer to this question cannot be found in the judgment in the Third Way Alliance party case, not because the court in that case was incapable of answering it, but because it is a question that was not asked and interrogated. In the words of explanation 3 of Section 7 of the Act, it is not a matter alleged by one party and either denied or admitted expressly or impliedly by the other. What is before us is a more specific question that narrows down from the question whether the President can generally form any committee of whatever form or shape on any matter to a more specific question whether he can form such a committee to initiate changes or amendment to the Constitution. This was a question not before the learned judge in the Third Way Alliance case. This is because in the Third Way Alliance case, the BBI task force did not have the mandate to initiate constitutional amendments. However, the BBI Steering Committee has, as one of its terms of reference, the mandate to initiate constitutional changes, which is the exact reason the petitioner in petition number 426 of 2020 is challenging its legality. And on that note, I hand over to my colleague. And then you need to finish that. 5.1. Sorry. Finally, it is for the foregoing reason that we are of the firm view that we are not stopped from discussing the constitutionality of the BBI Steering Committee and its mandate insofar as the amendment of the Constitution is concerned. In other words, this issue is not res judicata.
The other question that deserves attention and which we thought should be determined as a preliminary issue is whether Mr. Uhuru Muigai Kenyatta can be sued in his personal capacity and not as President of the Republic of Kenya. This is because he is named in his personal capacity as the first respondent in petition number A426 of 2020. A straight answer to this question is found in Article 143, Sub-Article 2 of the Constitution, but which we think it is better understood in the context of the entire article, and we have reproduced that article in this judgment. A plain reading of this provision of the Constitution reveals the following. Criminal proceedings cannot be taken against the President of the Republic of Kenya during his tenure as President. As far as civil proceedings are concerned, the President cannot be sued during his tenure if whatever is in issue for is something done or not done in the exercise of powers he is clothed with by the Constitution, where proceedings, whether criminal or civil, that may be taken against the President after his tenure are subject to limitation period. Time does not run until the expiration of his tenure, and the President may be prosecuted during his tenure if the crime of which he is prosecuted is defined by a treaty to which Kenya is a party and which prohibits immunity from prosecution. This bone of contention revolves around Article 143, Sub-Article 2 on civil proceedings. Only the Honorable Attorney General submitted on this point, and his argument is that it is not that the President cannot be held accountable for his actions while in office, but that whenever he is to be sued, the proper procedure to adopt is judicial review proceedings in which the Honorable Attorney General, rather than the President, would be named in the proceedings as a respondent. The bulk of the Honorable Attorney General's submissions on this point came in the form of a reproduction of a court decision in Julius Nyaroto versus Attorney General case, and we have